All right, so I think we're going to get started. So first of all, my name is Justin. I'm general counsel at Anyscale. Been doing this for kind of a while. I don't know in the audience whether or not you're coming into this with a fair amount of legal knowledge or you have absolutely no idea what a copyright is. So just quick show of hands, because it'll help me calibrate the conversation a bit. How many people actually have a fair background in law itself? Okay, all right, a half of a hand, that is good enough. Great, that's exactly what I prepped for, so it should be good. So first, disclaimers, I'm a lawyer, so basically this isn't legal advice. All right, and so as I noted, a brief primer in a couple of areas that are relevant for the conversation to talk about GenAI and IP. So basically there are two ways to protect your IP. You can either have statutory rights, which are the things you've heard of like copyright, patent, trade secret, or you can have contract rights. Quick note about contract rights. They're generally enforceable, but there are certain circumstances in which public policy actually gets in the way that may be relevant in the context of GenAI. And then most importantly, in order for a contract to be valid, two people have to agree to it. So unlike a copyright where you just create something and it has a copyright, you actually, if you want to protect your IP with a contract, need to make sure that you actually get someone to agree to it. So top line question, are the current legal frameworks, spoiler alert, no. So interesting thing about AI and GenAI in particular is it raises uncharacteristically novel issues. Almost everything else that has kind of come before the court, any kind of court in the last 200 years, has basically just been a minor variation on a theme. AI, for the first time, is all of a sudden, wait, all these laws were essentially written assuming that humans were doing things. And so copyright and patent in particular have basically not changed since the 1790s. There was a quick change in 1980 that made software explicitly copyrightable, but essentially the rights and the protections haven't changed at all. And you need to be a human in order to take advantage of them. So just quick on copyright. Basically, it protects creativity or creative expression and requires a human author. It doesn't protect ideas. It doesn't protect function. So when you take a look at a piece of software, the thing that is actually being protected by copyright, at least in principle, is the way you expressed your method. It's not what the method actually does. Important thing that we'll spend a fair amount of time talking about today is fair use. And essentially, in order for something to be fair use, it's a balancing test that requires going all the way to a jury. So generally, if you're trying to protect your own stuff or trying to use someone's stuff that might or might not be copyrighted, you don't necessarily want to have to rely on it because it means possibly getting sued. Four really basic things. One, the purpose and character of the work. You may have heard of something called transformative use. So if you take a book and you copy the entire book and you release another book, that's not transformative. If you take 1,000 books or 100,000 books and you make a search engine, for instance, to figure out like, hey, what's this book about? That might be. The nature of the copyrighted work, basically, whether it's factual or creative itself, how much you actually grab of it, and then whether or not your use is effectively making the market for the person's work you've copied less potentially lucrative. And notably, all the fair use things can be overridden by contract. Skip over patent rights because they mostly don't apply in the context of ML models. There may be some patents that cover some of the techniques that allow ML to be used, but the actual models themselves and the data and the weights and things are not protectable by patent, so we're just going to skip this one. Trade secrets is helpful potentially if you want to keep something secret. So if you're OpenAI, for instance, and you want to have your model available, so data in, data out, you can probably protect the weights of your model using trade secret because you're not actually attempting to expose them. But if you're Meta and you want to release Llama 2 and you need to get the weights out there, trade secret won't work because you've intentionally decided to disclose it. So hopefully that's a good quick primer. If anyone has any real quick questions, I can take them now, but otherwise I'm going to try to keep going through the materials. Awesome. Okay, so of course, XKCD comic, got to have the comic. You know, machine learning, there's three basic things that we might want to think about when we're talking about IP rights. The models and the code themselves, the data, in particular your data training set, or your training data, and then okay, someone has created an ML system. I want to use that system. What are the potential risks associated with using that? Or if I want to go take a bunch of stuff, do I have to worry about it? So on the models themselves, models are comprised, as you all know, code and model weights. The code very clearly is copyrightable. So when Meta releases Llama, all the code in the inferencing code and the machine learning code itself, and the algorithm piece, that stuff and how it's expressed, subject to copyright. The model weights, though, are actually the problem that basically there isn't a really good framework for being able to protect any of this. So model weights, generally speaking, are created by machine, and they're essentially a representation of facts. They're not themselves creative. They're not themselves an invention, so you can't protect them with either copyright or patent. But again, as long as you don't release them, there's a decent chance you can protect them with trade secret. So back to what I was saying before. What if you want to actually release the model? So this is where the contract piece comes in before. So copyright, patent, trade secret don't really help you for model weights. But if you do want to protect your model weights, what you can do is apply a well-written contract in order to cover them. And a really important point to note about this is almost all of the standard open source licenses that are being used to protect models, whether it's Apache 2 or someone decides to take like standard copyright language and do a proprietary license, but they want to like make it available in a source visible format, are probably actually not effective in order to protect the underlying model. And the reason for this is basically all of those licenses are written assuming that there is copyright to be licensing in what they're actually trying to protect. So when you release the model potentially under one of these licenses and you want to make sure that someone at least gives you attribution and notice, or you don't want to allow commercial use of something, if you're not really, really careful, you've probably accomplished that with respect to the portion of the actual code. But the model weights, which actually may be the more important thing that you're actually trying to protect, likely aren't covered by any part of the code itself, unless you're extremely explicit about it. And there's also this concept under copyright law, or in federal law, just generally speaking, called preemption. And there's a big disagreement as to whether or not copyright itself may even be able to preempt the underlying contractual language that you got someone to agree to. So if you do want to use an actual contract to be able to protect the way in which your model weights can or can't be used, the only way you can do it with any kind of comfort is to make sure that you use language that does not come from contract. So you can't use, transmit, or otherwise make available. None of these rights sound copyrighty, right? It's not reproduce, it's not make derivative works. Avoiding that kind of language will make it much more likely that the actual restrictions you're trying to place on your model weights would actually be able to be enforced. But it's also worth noting that trade secrets and even contract, when it's something like model weights, are practically speaking very, very expensive to enforce, because you don't have the statutory, hey, under the copyright regime, willful copyright infringement is $150,000 per infringing incident, that you can pretty easily go after someone and whoa, scared. But if it's contract, you've got to actually show damages. You actually have to go through discovery and all sorts of other expensive things. And this is true for both trade secret as well as the contract piece. On the trade secret side, you essentially can only go after someone on a trade secret violation if you can prove that they stole it or knew that they were receiving something that was unauthorized. So for instance, when the Llama weights in particular got released a couple of months ago and it was kind of a leak, the people that leaked them, they might have been able to go after them on a trade secret basis or otherwise before it was actually supposed to be released. But everybody else on the internet, probably everybody in the audience, that just oh, cool, Llama weights, gonna go grab them and use them, you probably would have been able to do it without any kind of real risk of potential legal enforcement, because you don't know. You had no particular reason to think that they'd been stolen or otherwise. They just showed up on GitHub or source, paste bin or whatever it might have been. So at any rate, that's a point. Don't assume even once you can protect something that actually you'll be able to rely on it. Okay, so that's ML models and code itself. So let's spend a second talking about data, including training sets. So essentially two questions here. Question on the one side is, hey, I want to protect it. Question on the other side is, there's a lot of really interesting data out there. I don't want to pay someone for it. I just want to go use it for myself. So what can we think about in terms of that? So as noted, training data itself, and I use data in air quotes, and I will keep air quoting on the stage, as annoying as that is, because when we talk about data in the context of ML, we often don't mean data in the way that copyright lawyers are thinking about data. And it's worth particularly noting that data can be two things. It can be either a bunch of numbers in an Excel spreadsheet or a Google Sheet or a SQL database or whatever it might be, or it might be an entire book or a video or an audio snippet. The book and the video and the audio snippet are certainly protectable by copyright. The list of data elements inside an array or a SQL database or whatever that have just numbers associated with them are not things that the US legal system generally protects with copyright. There is a concept under US law referred to as a compilation that may protect quote unquote databases in the US, but essentially it only works when the underlying database itself is creative. And most databases are not in any meaningful way creative. And so a good way of thinking about this is like, is it a cat or a dog? Not copyrightable. The database isn't copyrightable, the annotations or the classifications are not copyrightable, the database itself isn't copyrightable. You can spend all the time you want putting it out under a copyright and claiming whatever limitations you want on that basis. But if someone misuses it, you're not going to be able to go after them under copyright laws for actual infringement because they've not actually infringed any of your rights. It's just data, it's facts. So generally speaking, not a good way. Even if you pretend to rely on the contract, you're not going to be able to get very far. But on the other hand, subjective annotations or classifications actually might be protectable. So if you have something that's like, you're using like an ML system to try to summarize data sets. So on the input, you've got statutes or something like that because I'm a lawyer. The output, you're like, what the hell does this statute mean, right? Those things, and specifically whether or not they're good or bad or a accurate presentation or reflection or summarization of the underlying data, those might be copyrightable. But again, probably not something you want to rely on. Plug here, which is, I'm talking about US law. Copyright in particular is extremely variable across the world. Patent, almost not. Patent and trade secret, they're basically the same thing in almost every single jurisdiction with very minor variations. Copyright, however, has a lot of differences depending on where you are. So if you're in the EU, and specifically an EU company, you actually can get what are called sui generis database rights, which is like, I worked really hard to put all this data and facts together. It's a phone book, and I want a database copyright on it. And you can get that, but not in the US. OK, so let's go back to contract for a second. And specifically, I noted earlier that contracts can override your fair use rights. So let's take data in the book sense or in the audio snippet sense or whatever it might be. You want to go out and crawl the internet looking for data because you want to build an ML model that gets really good at classifying or predicting the next word, an LLM or something like that in terms of having it be a chatbot or whatever you might want to be. That, you're going to look at a bunch of information out there. You're going to call it data. Whether or not the data itself is copyrightable is again going to depend on kind of what kind of content it is. But if it's just out there on someone's blog or something like that, and there's not like an explicit license at the bottom of the blog, and even if there is an explicit license at the bottom of the blog, to my earlier point, there's a decent chance that license is not actually enforceable. There are things you have to do to make terms enforceable when you do it. The New York Times actually has taken an interesting approach on this, and I put a link at the back of the presentation in terms of how the New York Times thinks about it. But they actually very plainly, in the terms of service, which you have to pay to get access to almost all the New York Times right now. It's possible that those terms don't necessarily cover the stuff that you can read without paying for them. But certainly once you've gone through the process and say, I want to pay $9.99 a month for a digital access right to the New York Times, there is a clear sort of agreement, a manifestation of mutual assent is what it's referred to, where you've agreed, I'm going to pay you X. In exchange, I get Y, which if it were just a physical piece of paper or an actual newspaper, if those exist anymore, you could go buy it from a store, and then you could go sell it to someone else. There's a first sale doctrine which covers actual physical copies of things, where the moment you buy it, copyright kind of takes over, and you know exactly what the restrictions are. It's like, I can't basically take this and make 1,000 reproductions and go sell 1,000 reproductions. But if I want to like cut it up into pieces and like put a picture up on my wall with like the snippet of the article or whatever, there's no way that the New York Times would have been able to do anything about that. But once you get into the digital realm, where there is no concept of the first sale doctrine, when you agree to those terms in exchange for paying your credit card $9.99 monthly, the New York Times has something that says, hey, you were permitted to access all the materials in this on this site for quote unquote non-commercial use. And then it explicitly defines non-commercial use as all the normal things you would think, and then also taking this data and using it to train an ML model or similar in any kind of AI use. And the license, like the restriction, and I probably should have taken a copy of it, but you can look it up later, is actually pretty well written because it doesn't rely on these copyright concepts. And so there's a very decent chance that the New York Times has effectively prevented their entire sort of corpus of available digital works from being able to be read by OpenAI or Llama or whoever, Meta, whoever wants to like use them for those purposes. So that's the point here to note is like that kind of stuff is actually probably the only effective way that you can protect this stuff. But for everything else out there, because most of the internet doesn't really work that way. They're not paying a bunch of expensive lawyers to figure out exactly how to protect their IP in ways that might actually hold up in court. Most everything else basically just is like, I wrote a blog. You got the copyright the moment you wrote the blog because it's a creative work done by an author. I've now published it on my website. There's some implied license for the person to be able to read or access that material on your website. But generally speaking, that's where it stops. And so that's where you get back to this whole fair use question. And so we'll get into an example in a few minutes towards the end of the presentation. But essentially, it depends what you're doing and why you're doing it and whether or not it's for pay or for not pay. So let me just skip along to the next page. Really helpful diagram here. It's basically it depends, probably. It's like, what the hell? Okay, so two statements that boil down to the important piece, right? Copyright liability, and I hope you guys like the little animated GIF, and yes, I say GIF, so if any of you say GIF, I just can't handle that. But anyway, copyright liability is most likely if the model is actually regurgitating the training data. So if you ask ChatGPT or Chat Llama 70B or whatever it might be, like, give me a piece, like the first chapter of Harry Potter and the Sorcerer's Stone or something like that, and it responds back and it provides you Harry Potter and the Sorcerer's Stone, there's a decent chance that J.K. Rowling is going to be able to go after OpenAI for copyright infringement. And so what most of the creators of these large language models are doing is putting in place all sorts of guardrails that try to prevent this. And there's an interesting Stanford survey or study that's also linked at the back of this, where they're like, you know what? I remember being a really cool hacker in like the mid-90s. I remember using LeetSpeak to try to confuse my parents so they didn't know what I was saying on the internet. And let me replace the letter A with the number 4 or the @ sign or whatever. And they like made a bunch of queries to the actual LLMs. And as it turns out, it like literally will spit out multiple chapters of like one of the Harry Potter books from the training set. Like you ask it with like actual English words, it's confused. Like, I don't know what you're talking about. I don't know who Harry Potter is. You ask it using a couple of like well-placed symbols and ASCII art instead of text, all of a sudden you get the entire like complete works there. And so the point here is both on the guardrails piece, but also when you're training models, you have to be really careful about overfit models. Because the more that a model is going to regurgitate its underlying model or its underlying data when you actually like query it, the more likely you are to be sued by the people whose works that you went through and actually read in and used as part of your training set. And so I'll get in a few minutes to a couple of lawsuits that have happened over the last couple of months about this, and I'll spend a few minutes talking about them. But now first we'll turn to, hey, okay, someone else created a model. I want to use it. Is my lawyer going to get pissed at me? I don't know. We'll see. So note in the Adobe presentation today that one of the things, and he, shocking, he's not a lawyer, he didn't spend a whole bunch of time like trumpeting the indemnity that they offer, right? But basically, you'll find that most of the major corporations who are offering these services are all offering unlimited IP indemnity protection if you get sued for using the underlying content that is created in response to your queries. And the reason for that is they're pretty sure that what I'm saying on these slides, and I guess they're not behind me, over to the sides, what I'm saying on these slides, it's pretty unlikely right now, as long as you're not regurgitating stuff, that you're pretty unlikely to actually run into liability for using stuff. It is also, if you were creating stuff on your own, almost zero chance you can get protection in the underlying thing you're creating if mostly what you're doing is using the GenAI tool to create it. So if you're like doing autocomplete and you're not really thinking and you're like using Copilot or whatever and you're like, wow, that thing just wrote an entire method for me, awesome. Push it, hit the PR, like merge that thing to code, and you like really didn't do any thought processing at all as part of creating it. If someone ends up, maybe you accidentally leak the data on GitHub or something like that, someone grabs the stuff and like takes it, your lawyers wouldn't even be able to like get them to stop using it because all that stuff has no copyright protection in it at all. And this is basically a sliding scale when you're using these tools to create work. And you may or may not care about whether there's copyright in it because a lot of the stuff that it's auto-completing for you and that kind of stuff is fairly like rote and low-level stuff that might or might not be copyrightable anyway. But be cautious that if like it creates something really, really cool for you, you might not be able to get a copyright on it. And may or may not matter. But if all you're using it to do is like correct typos or, oh shit, this thing won't compile. Why won't this thing compile? Oh, you accidentally like called in the wrong database or used the wrong database schema or whatever it is. Like those types of generative AI uses are unlikely to cause you any kind of concern. So it's not like if you touch a GenAI tool, you won't be able to get IP protection in the thing you've created. But just be really thoughtful. And like most of the lawyers that I've talked to are basically trying to get their clients to say very clearly in the code, like when you have used a whole bunch of GenAI to actually create something. The idea being that like, if you're like, hey, this method was completely written with GenAI, these other 89 methods were not, you hopefully will be able to like point back to like the code history and be like, look, yeah, sure, this like minor thing that we don't really care about here, sure, we don't and we won't and we can't claim copyright ownership over, but the whole rest of my code base, when someone like stole my code base and like published it on Pastebin or whatever, that I can go get a DMCA takedown, I can do whatever I need to do to protect my own copyright. If you don't end up marking it, then the problem is like you need an entire jury trial to figure out whether or not the stuff actually has a copyright or not. And by that point, everyone's like misused your copyrighted stuff for forever. So you ought to be really thoughtful when you're using these tools to reflect essentially how much of what you've done was sort of generative with them. Okay. And so I mentioned that I would spend a few minutes on litigation. So there basically are 3 points here. One, there's the class action lawsuit that was filed against Copilot and GitHub. And this is basically that a whole bunch of people have a whole bunch of code under Apache or GPL or AGPL or MIT or BSD or whatever license it might be under. And the one thing that every single one of those licenses basically state is you've got to keep my notice file. You've got to say that I'm the one who wrote this thing. It's the attribution clause. And the essential claim that's being made against Copilot is those license terms are being violated. And probably fairly likely that this lawsuit's going to fail. It is probably practically speaking, unless, and this goes back to the regurgitation piece, unless a plaintiff can say, hey, here is a significant and non-functional portion of my code that's been reproduced once you actually query Copilot. You're not going to be able to go back and point to it and say, hey, that's actually my copyrighted code. And even if you are, the things they're pointing to, like the notice and attribution and other things, you still have to show damages because those are not copyright claims, those are contract claims. And it's really hard to actually prove any underlying damages for those. So you've not actually violated the copyright probably. You may have violated the contract terms, but they're not going to be able to prove damages. And so that one is most likely going to end. And there's the reason that Microsoft's like, yes, we are totally willing to offer unlimited IP. Like Brad Smith wrote a blog, like Microsoft will stand behind you when you use Copilot. And it's because they're not worried about these things. That said, don't know if you've ever noticed or if you were listening to Ben Horowitz today during the presentation, people who are making the laws in this regard and people who are interpreting the laws, i.e. judges, are often not all that technical. And the problem is, as I noted before, these are all pretty much issues of first impression. Like there is no actual precedential case that anyone can point to and say what I'm saying is correct or not correct, or what Brad Smith is saying is correct or not correct. And so it is not that unlikely that you might find a judge in like the Ninth Circuit or something in California that's, what? No, this is absolutely horrible. They've infringed this copyright. And it's like, uh-oh. This might actually be the law of the land for at least a part of the United States for a period of time because there isn't clarity on these points. And you could very easily, because the community of people who create sort of creative works, authors, whether image creators, photographers, whatever, obviously have a vested interest in protecting themselves. So like, you have a whole lot of lobbying on the favor of like, let's make AI like flatly illegal. Like it's a violation of everyone's rights to use it. And it's possible that that'll happen. And that gets to the Getty images versus Stability AI. One, I don't know if you guys have seen any of these pictures, but it's hilarious. A lot of the training set for Stable Diffusion very obviously was like scraped from the Getty image thing. And so there'll be like extremely grotesque, like weird images with like Getty images in the thing. And so Getty is going after them for both a trademark case as well as a copyright infringement case. Getty is pretty likely to win, I think, again, because of the regurgitation point. Their Getty Images logo is like appearing all over these points. They'll probably at least win on trademark, if not on patent, or if not on the copyright piece. And then the other one to mention is the Anderson versus Stability AI. And this one is, again, basically the judge himself during the oral arguments, basically saying like, you haven't shown me an example of something that's being regurgitated. Thanks, Thomas, I got you. Like, you probably have nothing to do here. So with the last 2 minutes, and we can definitely interrupt me because I've been talking for 28 minutes now with questions, but let's just like walk through these things at a high level. So let's say you wanted to create a tool or website. You want to transcribe third-party audio podcasts. This is your quote data. If you want to publish those things and charge for them, you might have a problem there because you may be, particularly if you're taking those things and removing the ads that all the podcast producers have put in to monetize their own podcasts. That's going to very clearly be a violation of their copyright, and you would lose pretty badly. On the other hand, if all you're doing is pointing to them, podcast aggregators are allowed to do what they are allowed to do, basically on a fair use point, because they're actually not getting in the way on that fourth point of fair use I was talking about before, where you look at the effect of the market. You're actually enhancing their market because you're pointing to their podcast and you're pointing to their ads so they can monetize their stuff. Let's say you wanted to generate summaries, publish transcripts. This would be a little bit on the edge because, again, you're going to remove the information about the underlying ads and things like that. But maybe you want to create a chatbot to interact with those and then point back. This probably takes you back onto the other side of the fair use piece. And then the last thing I'll say in the last 30 seconds is, I don't know if you guys saw like the Drake AI song, like the fake Drake song or whatever. He probably was only successful at being able to get that thing taken down because there was an explicit and very small snippet of something that was directly regurgitated from the training data set. If that hadn't existed, the only way he would have been able to protect himself is on the basis of a so-called right of publicity, which again is very weird and is only state-based, and most states don't have anything at all. And so it is very likely, and you should be careful when you're using your own voice in these things. You can create a model. If you're not famous, someone could take your voice and go create a model and go do whatever the heck they wanted to in that, and you wouldn't be able to do anything. So, okay, takeaways, you can just read them yourself. Basically, unlikely to be able to get any protection for actually using generative AI, unless it's just really minor uses. These things are really novel and untested, and everything I've said is subject to a hell of a lot of uncertainty. Contracts, particularly if you're trying to protect model weights, are A, the only way you can protect them, and B, the most likely way to be successful. Just make sure you don't use copyright language in doing so. Everything I've said about sort of whether you can use training data and the fair use issues are totally questionable, but I think most practitioners would agree with my positions here. And yeah, that's it. Questions? Yes. Oh my God, 2 questions. I love it. It depends, because to the extent you could claim any protection at all, it would only be in your edits. It's not like your sudden editing of what it created suddenly imbues copyright protection on the whole, right? This goes back to my point about like annotations in a database. If I say that this thing is beautiful or like heartfelt, that part's going to be subject to copyright, but all the functional things that it created, you're not going to get any protection on at all. So editing it does not suddenly solve this problem. It basically depends on whether or not the vast majority of it was human created. The prompt engineering piece is definitely not going to solve it, because like ultimately, and this is basically why these things are not well applicable to copyright. Like it's a good argument in theory that like I have told this tool to create something for me, much like I have told this, marker or this paintbrush to like do this. But ultimately, the ability for you to point to inputs and show that that's what generated the outputs in any like creative link is almost certainly to not exist. So I would be extremely careful trying to rely on something like that. It'll almost certainly fail. Yeah, comment in your code or whatever, yeah.
Are there any particular common structures that you would advise developers to do, how they segment their code?
The thing I would suggest is to come up with a string of characters that is meaningful to you, but not the rest of the world, so that you don't have like clear evidence through other people to be like, hey, take my code, this part is generative AI. So that would be the one suggestion I would make, but beyond that, it doesn't really matter. All right, I know, I'm done. Last question. No, so you can create, this is a very good question. You are absolutely authorized under fair use to create an archive for personal use. You might also, subject to the contract point I made before, be able to make a transformative use argument to allow you to use the training in the first place, but it wouldn't be based on the exception that allowed you to have the piece by itself. It's a secondary analysis. Okay, cool. If anyone has any other questions, I'll be up front.